and good day. A very warm welcome to everyone joining us from all over Asia and also from different parts of the world. Thank you for joining us for today's webinar organized by Un and Bazul in strategic partnership with the Singapore International Mediation Centre, SIMC, and supported by Khaitan Co and the International Fraud Group. We're very pleased to present today's webinar titled Building Bridges and Effective Advocacy, Asian Approaches to Mediation and Commercial Conflicts. My name is Grace Lowe, and I'm the Director of Business Development at Un and Bazul. Our distinguished chairperson is Mr. Bazul Ashhab, Managing Partner and Head of Dispute Resolution of Un and Bazul, and Ambassador of SIMC to Indonesia. Now, without further ado, I wish to welcome Mr. Bazul to give his opening remarks.
Good afternoon, everyone. My name is Bazul, and I am the head of dispute resolution. Give me a minute. Okay, so we had some technical issues and that has been resolved. So I'm the head of dispute resolution practice, and those who have encountered me or have an opportunity to work with me will know that I thoroughly enjoy resolving disputes. You know, I like the idea that I'm in the business of persuading decision makers. And it's a fair assumption that given that I'm involved in commercial dispute, that those decision makers are rational and reasonably minded. Now, given that I practice, my substantial practice involves cross-border dispute, to me, it is absolutely fascinating how different cultural and language nuances affects perception of reasonableness and rationality. And this is particularly relevant in mediation. I intend to unpick through this webinar the reasons why mediation should be seen as a significant mechanism to resolve disputes. After all, clients want their lawyers to resolve their disputes as quickly and as painlessly as possible. I suspect this is what has contributed the growth of the firm from its humble beginning of 2 lawyers to currently about 60 over within such a short frame of time. Thank you for joining in, and I hope you enjoy the session we have prepared for you. Grace?
Thank you, Mr. Bazul. And we wish to welcome our esteemed speakers today. We're delighted to have with us from Singapore, Mr. Chuan Meng, Chief Executive Officer of the Singapore International Mediation Centre. From China, Dr. Arthur Dong, partner of AnJie law firm and ambassador of SIMC. From India, Mr. Raj Panchmatia, partner of dispute resolution of Khaitan Co and specialist mediator of SIMC. From Indonesia, Pak Fahmi Shahab, executive director of Pusat Mediasi Nasional and ambassador of SIMC. From Japan, Mr. Hiroyuki Tetsuka, partner of Nishimura and Asahi, ambassador of SIMC. And from Malaysia, Datuk Kutubul Zaman, senior partner of Monsieur Zaman and Associates, ambassador of SIMC. From Singapore, Mr. Lionel Chan, partner, litigation and dispute resolution at Un and Bazul. And from South Korea, Mr. Kevin Kim, SIMC board member, international mediator, and senior partner at Peter & Kim. And now please sit back and enjoy a video highlighting the expertise of our esteemed speakers. Just to highlight some housekeeping rules before we get started. Today's webinar is scheduled to last 2.5 hours, including the Q&A session. All participants will be muted to allow a smooth session without interruption. And please note that this session is being recorded, and we will share the recording link after the webinar. And we welcome you to review the content again and share it with your colleagues. If you have any questions during the presentation, do type them into the Q&A box in your Zoom control panel, and we will save it for the end of the session during the Q&A. And now to get everyone warmed up, let's dive into an opening poll to gather the audience's thoughts around mediation as a dispute resolution tool. We invite you to participate by selecting your responses when they appear on your screen. So the first poll question, how effective is mediation perceived in resolving commercial disputes in your jurisdiction? Is it effective? Is it ineffective? Or you're neutral? It depends on the dispute. Have you had a personal experience or known of a colleague who has used mediation to resolve a dispute? Yes or no? And what is the likelihood for you or your organization to utilize mediation in a dispute? Is it likely, unlikely, or neutral? Dear audience, please submit your answers. And the voting time is up. Let's now look at the voting results. So very interesting answers we have here. Thank you, attendees, for your votes. And we have 56% who think that mediation is effective in their jurisdiction. 3% think it's ineffective, and 41% remain neutral. Okay, we have 83% who have personally used or known of a colleague who has used mediation, and 17% who have not used mediation and do not know of anyone who's used mediation. And we have 81% of the audience who are unlikely or their organization is unlikely to use mediation, and 19% who are neutral about that. So I would now like to invite Mr. Bazul to comment on the poll results.
Okay, it's interesting. So I think the focus on the panelists of this webinar as well, the burden is on the panelists to convince the neutral to see at the end of this webinar to conclude that mediation is effective. And it does look like many of those who are participating have experience. And again, the neutral, as far as the likelihood of the organizing using it, we need to shift them to the light. We hope to do that. And let's see how the delegates feel after the session.
Thank you, Mr. Bazul, for your comments on the poll. And ladies and gentlemen, Mr. Bazul will now give his keynote on achieving settlement through mediation, devising solutions for desired outcomes. Please welcome Mr. Bazul.
Thank you. Good afternoon, everyone. My presentation would deal with achieving settlement through mediation, devising solutions for desired outcome. I've broken it up to 4 parts. First, I will highlight the reasons why there is a reluctance to utilizing mediation, which often arises from misconceptions about the mediation process. So this could take the form of commercial parties' psychological biases against mediation. There may also be issues about the quality of the mediation services, meaning expertise of the mediators and mediation counsels in that jurisdiction. Now, what I intend to do is debunk these misconceptions by demonstrating that such perceptions are often misconceived. Thirdly, I want to touch on the commercial benefits of mediation, why it is so attractive and gaining traction worldwide as a credible dispute resolution process. Finally, I'll wrap off my presentation by giving some practical tips which mediators and counsels may adopt to bring about a settlement. So, what are the misconceptions which disincentivize parties to adopt mediation? The first one is the suggestion that proposing mediation is a sign of weakness. I have heard this numerous times. Whenever I suggest mediation, my clients tell me that, hey, hang on, a party suggesting mediation, will the opposite party think that the suggestion is coming from a place of weakness? Firstly, let me assure you that those lawyers or we who are involved in cross-border high-value disputes recognize the fact that mediation requests do not spell weakness, but an opportunity for parties to put their head together to narrow their differences and reach a settlement. In any event, it is becoming common practice that many courts in various jurisdictions have made it necessary to mediate at a very early stage. For example, Indonesia and India, as an example. Now, next question I often asked is the timing of a mediation request. When should that request be made? Again, it is aligned with the question of whether putting forward the request at a wrong time, would it suggest weakness? Now, generally speaking, in terms of timing, I find this often the case. When a case is started, emotions are raw. It is best to have the emotions settle down. And again, speaking generally, it is best to suggest mediation to our clients after parties have exchanged their initial case statements and when parties have incurred costs. And the prospect of incurring more costs, generally speaking, will make parties to be more ready to the suggestion of mediation rather than thinking that a suggestion will lead to weakness. Now, in litigation, it is important to bear in mind that there will be many battles down the road. But ultimately, what is important is winning the war. So you can win many battles, but can still lose the war. Therefore, my suggestion to my client is when they have won an important battle, it is often in their interest to propose mediation instead of wishing to beat the other chap to a pulp. For example, when I have obtained a freezing order, when I see that there is a non-disclosure and I take up a committal proceeding, I would actually recommend to my clients to propose mediation at that point of time. Because the other party is staring at the risk of getting an imprisonment or a heavy fine. And he would be more likely than not to accept a reasonable solution if it is put forward or through a trained mediator. So choose your opportunities to mediate, to assuage your clients from that misconception that proposing mediation is a sign of weakness. Now, the second misconception is mediation lacks enforceability. This is not true. Mediation has teeth. As a mediation settlement, it is enforceable through the Singapore Convention on Mediation, which came into force on 12 September 2020. Moreover, mediated settlement agreements can be recorded as a court order in Singapore and subsequently also enforced in foreign jurisdiction through the various bilateral and multilateral treaties Singapore has with other countries. This will be discussed by my friend Meng from SIMC, and also I will touch on this in my panel discussion. The third misconception is that mediation process cannot be trusted and may be used for improper purpose. Now, the common concerns are, would the opposite party who has a weaker case, would they use mediation process to delay the matter or even obtain discovery or fish for information which they may not be entitled to at that stage or at all during the legal process? Now, my suggestion to those concerns when expressed is that you can actually structure the process, because the control is with the parties and not the mediator. When these concerns are expressed strongly, robustly, I have suggested to my clients and the opposite party that very strict timelines are set for exchange of mediation statement, as well as for the mediation to be conducted. Now, if I had in the past had a mediation completed within 2 weeks from a request to mediate. Now, so as I mentioned, you have the control, or the parties have the control and the autonomy to decide on the conditions to set for mediation. Now, I tend to look at who is the critical person who, if he attends the mediation, is likely to reach a settlement. So once I've identified that individual, I'll make it a precondition in certain mediations for that particular person to attend the mediation. Now, I also, in some cases, make it a point to say maybe the critical information about the matter should be exchanged fairly between parties so that a settlement is more likely to be reached. I can assure you, the mediator has no power to order discovery, as the process is controlled by the parties. And lawyers, we are familiar with the process, and we will not allow mediation to be used as a discovery process, and it will be shut down. Any request, unreasonable request for documents will be shut down immediately. All mediation communications are kept confidential, so parties don't need to worry that anything which they have discovered can be used subsequently in any other form. You can actually obtain an injunction to stop such usage. Now, the fourth misconception is that if I were to settle this matter, would there be allegation made against me as the party settling? Could there be an allegation of corruption, incompetency? In certain jurisdictions, I'm often, especially when I am dealing with a public undertaking, I'm often faced with this pushback whenever I suggest mediation that, hang on, we rather have the law takes its course because we don't want any impropriety suggestion made against us. So in those instances, what I focus on is the assurance that a mediation conducted by a institution with first-rate reputation, for example, SIMC, who has highly trained, experienced mediators in their panel. A mediation process which is transparent would address that concern. Now, if you look at SIMC's website, one can easily tell that the overall success is about 80%. And my own experience in mediation is about 70 to 80% as well. Now, the fifth misconception is that, look, mediation is just ticking the box. We're going to spend time and cost. It's not going to be effective. Now, this comes from experiences which users have from court-led mediation. What I mean is this. So in many jurisdictions, before you can start your action or at a right juncture, at an early juncture, the courts appoint one of their judges to sit as a mediator. There, the judge would have 50, 60 cases in front of him. So he sits with one party half an hour or both parties half an hour and say, look, I mean, these are the issues. Are you going to settle or not settle? If you're not going to settle, let's just go on with the matter. So the experience seems to be that, look, it is going to be a waste of time from their past experiences, court-led mediation. But in reality, mediations which are conducted by a specialized institution, specialized mediators will lead to a settlement. Now, reputation of the institution is critical. Again, as I understand, SIMC has administered more than 130 mediations. Total value to date of the dispute is 3 billion. These cases are high value, high stake disputes. Now, I want to touch now on general benefits of mediation. Now, parties are, first benefit, parties are directly in control of the settlement discussion. You're not abandoning this process to a judge or an arbitrator. There you lose control. Because the moment you have finished your advocacy or the lawyers have finished your advocacy, the control is with the judge or the arbitrator. You lose control of the decision immediately. Now, whereas in mediation, parties have the control. How you put together a settlement is within your control. You can achieve a win-win as opposed to a zero-sum game if the matter goes before a judge. Now, mediation is also unique because it gives an opportunity for me, if I am the mediation counsel, to speak to the end client at the opposite side instead of speaking through their lawyers. My experience is that many can make unreasonable demands through their lawyers, but when spoken through directly, they generally speaking do give in to a reasonable suggestion. My experience is also that you can take an unreasonable position through email, even on the phone. But when one is looking through the opposite side in the eye, or in a hybrid situation, Zoom, as I'm looking at you, it's still difficult to take an unreasonable position. So as a technique, when I'm speaking in the joint caucus, I do not speak to the mediator, but rather to the opposite side directly. Now, even if a mediation doesn't lead to a settlement, mediation can assist in narrowing down the issues. From experience where the matter was not settled through mediation, that particular matter involved about 15 complex issues. Through the assistance of a trained mediator, and counsel on the opposite side was extremely reasonable as well. We managed to narrow it down to 2 issues, which subsequently went to arbitration. The cost was substantially reduced. If the 15 issues would have gone into parties if had to deal with the 15 issues, I could have easily end up in a 4-week arbitration with multiple witnesses. Because we narrowed down, we actually finished it within 3 days. Now, the third benefit it gives is it allows the mediator to extract the true interest and true objective and allow parties to reach a win-win, as I've suggested. I'll give you an example. So where 2 children fight over an orange, but they may actually want the orange for absolutely different objectives. Child A may want the orange for its orange peel to bake a cake. Child B may want the orange to make orange juice. If you if you try and get into the objective, both children's interests can be satisfied at the same time. It sounds simple, but from experience, I tell you, if a mediator and mediation counsels drive into the objective, you can actually see where the interests are commonly aligned and bring a settlement. Another benefit is that mediation can take into cultural differences. And if you take into understand cultural differences and nuances, it can assist actually in limiting issues and explain. Sometimes it can bring out that the difference is effectively from perception rather than real. So you can actually use that as well to preserve relationship between parties, which often are destroyed through a painful process of cross-examination or painful process of court-led litigation or even arbitration for that matter. Now, I want to talk about practical tips. I'm in the end of last part of my speech. Now, as a mediation counsel, I tend to tailor my presentation and techniques depending on the psyche of the parties involved, circumstances and facts of the dispute I have to deal with. It's so interesting. There is so much psychology at play when you are resolving the dispute through a process of mediation, as opposed to a court process. There, I need to persuade the judge. I need to understand how the judge thinks. Whereas and cultural issues don't really crop up. But in mediation, one needs to look at the cultural backgrounds. There is a study on Hawthorne effect, and there's a website which actually deals with how culture can come into decision making. I would recommend that you look up that website. Now, actually, there's an interesting point. Depending on the cultural background, parties may not divulge their true intentions, especially personal interests. A trained mediator or counsel can bring this up. There may be a need to uncover whether there is a divergence of interest between the company and the decision maker. Whether a particular settlement, even if it is good for company, may embarrass the CEO. And once discovered, the mediator and counsels can put together a way to package it so that it can avoid and follow. Communication styles are extremely important. There may be a perception of rudeness in a particular culture. Interruption will not be tolerated. And mediation, what is critical is good listening skill. I actually spent a lot of time looking up the interest background of decision makers and what would embarrass them from a reputational point of view, so that I can work out the best approach to present and adopt in order to bring about a settlement. Now, I hope my speech was useful. Grace, that's the end of my speech.
Thank you, Mr. Bazul, for that very interesting keynote and for explaining the commercial benefits and mediation's credibility as a highly effective dispute resolution tool. And next up, we have Mr. Chuan Meng, CEO of SIMC, to speak about the Singapore Convention on Mediation, a game changer in international dispute resolution. Please welcome Mr. Chuan.
Thanks, Grace. So first of all, thank you to Bazul and the firm Un and Bazul for inviting us today, and we are very glad to be the strategic partner for this event and to be part of a really esteemed panel here. And also to everyone who's joining us this afternoon, thank you for joining us. I hope that this will be very useful for you and we'll have an interesting discussion. So my topic is really about the Singapore Convention on Mediation. So I'm going to talk a little bit about that. Then I'm going to talk about what happened to the convention after that, the rise of ADR, hybrid ADR. I think you will find that very interesting with some data there. And then finally, a very simple example of what a typical case is like for us here at SIMC. So with that, maybe I'll start with what is the Singapore Convention on Mediation. Just a couple of very simple charts here. First of all, the convention is really to ensure that parties are able to enforce a mediated agreement across different countries. That is really the primary reason. If you think about the New York Convention, it is used to allow arbitration awards to be enforceable. In that same way, the Singapore Convention is to allow mediated agreements to be enforceable. Now, the other concerns and benefits, of course, will be that the convention recognizes how mediation has grown over the years, especially commercial mediation, how mediation helps on cost benefits, time benefits. It encourages how international trade is being done across the world, because if you have more options of being able to mediate disputes, the more parties have confidence in doing the business in each country. And of course, lastly, it contributes to harmonious relationships within the country, across countries, between governments, and for multinationals that are operating in so many different countries, it really helps the parties to resolve the issue. So I was the general counsel for IBM here in Asia Pacific, and I'll tell you, my first experience with mediation was really through IBM, where I sat as a user and understood the tremendous benefit of being able to resolve complex issues through mediation. Arbitration is still important, but you will see the rise of hybrid, which I'll talk about in a while. The next chart, please. You see, this is a beautiful photograph of what was the signing ceremony of the Singapore Convention on 7th of August, 2019. It seems so long ago with the pandemic. This was when we could still travel, and we had really all the leaders from various countries. I think there were 40 to 50 countries that were represented here. And we had a wonderful ceremony here led by our Prime Minister, Lee Hsien Loong, and all the different representatives. You see the representative from United Nations as well. And with the signing of that agreement, it marks a milestone change in how mediation is being seen by courts, by law firms, by business leaders, by business federations all over the world. Right? This is the most successful convention that was signed where you had so many participants on the first day. So amazing. And as you can see, they come from all over the world. Next chart. So what has happened since the 7th of August, 2019, when it was signed? You will see here that our minister, Edwin Tong, is with the United Nations legal representative, Mr. Suarez, where we not only signed the convention, but we ratified it. And because of the ratification of 3 countries, as of 12th of September 2020, and this is the important date, the convention has come into force. So not only is it a signed convention where people sign up, but the convention now is enforceable for the countries that have ratified. And which are the countries that have ratified? You will see in the next chart. So you will see that the number of countries that have signed, 53 so far, really comes from all over the world, whether it's Asia, Europe, Africa, Latin America, and 6 of these countries have ratified. There are many others that are working right now, and we are working closely with many of these countries to have the convention ratified. COVID has not helped, I would admit, but we are certainly on the way there. And amongst the countries that have signed, you would see that you have North America, you have China, you have Asia, you have South Korea, some of the biggest economies in the world. And you would also see that there's a large presence here in Asia, where many of us are based right now. So this is an important convention that is taking force, that has gained momentum, and will continue to gain momentum as COVID is lifted. The next chart, please. So you will see this is really a chart on economics, right? 3 of the largest economies of the world have signed on the convention: the US, China, and India. And together, they represent, just these 3 countries, 40% of the global GDP. And these were figures taken by the United Nations. And on the right side, you will see that Asia's economy is the one that's driving the growth around the world. So here you see that more than 70% of the growth of the global economy is pushed by these few countries, and all of them have signed up on the convention: China, India, South Korea, ASEAN, etc. So whether you're talking about the size of the economy or you're talking about the growth, all these countries have participated in the convention. That's the exciting news. Next chart. Let's talk about the rise of ADR. I think that's where many of us will find it interesting that from 2015 to 2021, over the course of just 6 years, you will see that international arbitration with ADR, which is mediation, what we call a hybrid process, is on the rise. In 2015, it was 34%, 2018, 49%, and in 2021, it hit 59%. You just see the tremendous growth. And these are taken from the Queen Mary survey with White and Case. And as you see that rise there of the hybrid convention, hybrid mediation with arbitration, at the same time, you do see the slow fall of pure international arbitration to deal with international commercial disputes. In 2015, it was 56. It's 2018, 48. And in 2021, a big drop to 31%. These are almost mirror images if you look at them side by side. With the rise of hybrid ADR, there's also a fall of pure international arbitration. So don't get me wrong, I know many of us are very much focused on arbitration, and it continues to be very important. It is really the backbone of how disputes are resolved on cross-border disputes. It still continues to be very important. But what this data shows is that just international arbitration on its own, that is falling. What parties want, what parties require is for a hybrid solution, not just pure international arbitration, but international arbitration with mediation, because the parties see the benefits, the wonderful benefits of what mediation can bring as not as an alternative, but as a collaborative process together with arbitration. That is the data that we are seeing right now from the Queen Mary survey. Very critical for the last 6 years. And this is just within a short time. You think about what's going to happen when we look at the 2024 results, which is, it's because it's done every 3 years. Maybe we'll have another talk, Bazul, in 3 years' time, and we can look at the data. So next chart. So in the same way that we have seen arbitration grow, I want to just talk a little bit about SIMC's caseload, because we have so much focus on international commercial complex disputes. So this is the 2019 results, which is really very consistent with what we've seen when we started in 2016. This is the rate of growth, right, with the 2019 numbers. And then in 2020, with COVID, we see a tremendous change. Suddenly, this rate of growth, you see this exponential growth. From 23 in 1 year, we hit 43 in 2020. That's almost double what we did in 2018. And then if you look at the 2020 numbers, of course, we look at 2021 numbers, sorry, we have not finished the year yet. We're still in May. We're already at 36. So, we are almost doubling every year from what we are doing from the previous year. Again, I'm sharing these numbers because we are a non-profit organization. We're not here to tell you how great we've done. What we're doing here is just to share with all of you that this is what's happening in the market. This is a reality of the growth that is exploding, perhaps partly because of COVID, also partly because of the convention for sure, and also the awareness and the knowledge of different parties now understanding how important mediation can be. Right? And the type of cases that we see, as you can see there, is almost all of them are cross-border, international. They almost always have nothing to do with Singapore. And I'm happy to talk about that a little bit later. You will see that India is 23%, China 16%, US 11%, etc. And all the speakers on the panel, on this esteemed panel, they all represent the countries here that is on the pie chart, all with very significant, substantial matters that are being heard in SIMC. What is more important is that we have 170 cases to date, and most of them are really over the last two years, as you can see from the previous chart. And the dispute value is large. It's more than $4 billion. So on average, you're looking at something like $25 to $30 million. And for this year, right, 2021, January to now, the number of cases that we have, 30 over, is more than $1 billion in terms of dispute value. So not only the quantity of cases that have gone up, the quality of the cases, if you consider dispute value as one of the factors to determine how complex the case is, that has gone up substantially as well. And the average settlement rate, amazingly, has remained at 70 to 80%. So that's really fantastic news for all of us who practice mediation. It is on the rise, very fast, gaining momentum across different countries, very much represented by Asia, as you can see. And at the same time, settlement remains at a very consistent 70 to 80%, and we hope to keep it there. The next chart. So when we talk about the enforcement of mediated agreements, of course, the convention is helpful, but at the same time, they will take time. So we still have the AMEDAP, which we have with SIAC. I know many of you are familiar with Singapore International Arbitration Centre. And with this process, which is really a one-stop process that will take place within 8 weeks. Within 8 weeks, you will determine whether the mediation is successful. If successful, of course, the parties do not need to go through the arbitration, save quite a bit of time and money. But if it's not successful, within that 8 weeks, it goes back to arbitration. So the delay that Bazul was talking about there was very, very minimal. And with the mediated agreement, if you have it settled, you can register it as an arbitral award, then you can enforce it in more than 160 countries around the world. And all those benefits are there: time and cost saving, neutrality, access to mediators, multi-jurisdictional enforcement. Next chart. I want to spend just a minute on this because it is so important, right? In the past, mediated agreements generally do not get enforced as an arbitral award if you do not start off as an arbitration, because of the concerns that, it wasn't, by the time you come to mediation, it's no longer a dispute. However, we have a signed an MOU with the Shenzhen Court of International Arbitration just last year, where they have agreed to enforce mediated agreements in SIMC. The reason is because they understand and work with us, and they know that mediated agreements in SIMC are trustworthy. There's a process. The risk of fraud is very low. And therefore, this mediated agreement, although it didn't go through arbitration, can be registered as an arbitral award in SCIA, and then from that, enforceable in China. So for all of you who are not in China, if you have clients or you have contracts in China, if you have a dispute, you can just mediate it in SIMC with a mediated agreement. You don't even have to go through the arbitration process. With this MOU, we're able to go to SCIA to have it enforced, registered, and then enforceable in China. So this has garnered a lot of interest for people who have business in China. And it's really one of the first in the world. Next chart. So very quickly, a recent example, just to give you an idea of the type of cases that we do. We had an AnJie case that was between a European party and an Asian party. I can't review who they are, but it spreads across 5 different jurisdictions. It went on for 5 days, where we were only able to, because of time difference, we start here in Singapore at 4, 5 o'clock, and we end at about 11 o'clock for about 5, 6 hours. And it stretches the time zones, the different time zones. I think it's about 12-hour time zone. 8-hour time zone, I'm sorry. 8-hour time zone with the UK. And the parties were able to have the matter mediated on one platform with all the parties involved. So this is just a very good example of how, in fact, this matter had nothing to do with Singapore. The only thing that we had in Singapore was SIMC. All the lawyers were international law firms. I guess this shows that cross-border complex mediated agreements are now the go-to. It's almost the first port of call to have these matters resolved. So I'm going to end off by just saying that, in all disputes, there are always 2 sides to it. There are always the pros and the cons. The one side has the argument, the other side has the counter argument. Even a sheet of paper has 2 sides. So the question is whether the 2 sides can be used constructively, creatively to create an origami like in the next page. So with that, I want to thank you, and I'm happy to join the panel for the discussion that we will have. Thank you.
Thank you very much, Mr. Chuan. And now it's time for our panel discussion. I shall hand it over to our distinguished chairperson, Mr. Bazul, to moderate the panel discussion on transforming conflicts through mediation and Asian regional dialogue.
Thanks, Grace. As everyone before me have said, we have an esteemed panel. And let's try and gain insights from their experience in mediation. Now, I want to start with speaking about trends in each jurisdiction. Maybe I'll start with you, Arthur.
Yes.
Arthur, can you tell me what are the general trends? Is mediation picking up in China? And tell us whether there's something which we need to know in terms of how mediation is perceived in China.
Yes, thank you, Bazul, and congratulations to this event. For this question, I would like to share with our audience that the observation from the Chinese perspective. First of all, as we may know, China is having a long history of resolving disputes by mediation. Recent developments, I would like to say that the traditional way of mediation is to resolve the disputes in the civil area. And in recent years, from the Supreme Court and even to the central government, both of them are encouraging mediation to be used to resolve the disputes in the commercial area, especially in the cross-border commercial disputes. It's a very noteworthy phenomenon in recent years in China. The other point I would like to say is that also a recent development that is a traditional practice in China that the arbitrator and the judge, they wear 2 hats actually. The judge and the arbitrator could be the mediator in the same case. It's a long history practice. But in recent years, we realize that maybe the clients or the companies from the common law background, from the other jurisdictions, may find it not easy to accept this practice. So more and more leading international arbitration institutions like CTEC, like SCIA, they began to adopt that the new provisions in arbitration rules that provide the opportunities for the parties to look for independent mediator in addition to the tribunal members. If the parties want to look for an independent mediator, there will be a basis in the arbitration rules. And the third development I would like to share with our participants is that, as Bazul and Mr. Chuan just shared, that China has signed the Singapore Mediation Convention. Yeah, it will be a good news for the international business communities. And we also are keeping close watch with the process when the Chinese legislature may decide to ratify this convention. There will be also big news in the international commercial dispute community. Thank you, Bazul. And I would like to briefly share these 3 points for the reference for our participants. Thank you.
Thanks, Arthur, for that. I hope China ratifies. And I'm sure those who are doing trade with China would wish China to ratify so that disputes can be dealt with efficiently through mediation. Now, what you said is so interesting about a judge also sitting in as a mediator, or an arbitrator sitting in as a mediator. You know, when I first came across that, given my background is the common law background, I found it difficult to appreciate. But with experience, I can see how in some cases that may be useful, where you know, there are decisions which have said this, and some judges do say it, that just because they express a view, and because judges are intelligent, or we hope they are, because they are intelligent, an intelligent mind cannot not have a view. In fact, as an advocate, I like going before a judge who would express a view, so I know what he's thinking when I'm advocating in front of him. So I can then try and persuade him if he's not on my side. So a mediator, especially in certain cases where it requires an evaluation rather than a facilitation, where you bring in his view on the matter with a guarantee, and a tactful arbitrator or tactful mediator will be able to do that. That is not making up his mind, but giving his view, and the parties are free to take it or dismiss it. And he's not going to be influenced by the view when he makes his decision, because he has not fully thought through. I think it is helpful. It's interesting you mentioned it. Now I'm going to go over to Kevin. Kevin, can you tell me how popular mediation is in Korea?
Yeah, thank you. In Korea, actually, court litigation, we also have similar tradition that the judge involved in the mediation, also a type of mediation, and sometimes issue the mediation order, and judge just continue to sit as on the case. So we changed the system several years ago, and now we have separate specialized mediators. Normally a previous judge, they're listed in a court, and the case is assigned to the mediator. The mediator review, and normally mediator issue the recommendation. So that is a quite unique part, that the court parties will receive the recommendation from the mediator, and the judge also can assess and evaluate the recommendation by the mediator. That is the court practice. In case of arbitration and domestic arbitration, we have, Korean society became very interested in mediation. We always are interested in mediation, actually. But the interesting thing is the international arbitration, for recent years, mediation has become very popular. So the Korean society is very trendy. We are willing, we are prepared to accept whatever is a popular or whatever is reasonable, internationally acceptable, we always volunteer to take such a trend. So that is the case in with the UNCITRAL, a model law, and they apply to any standard. Actually, we're happy to accept. So the Korean parties rapidly accept and try to utilize the mediation concept in the middle of arbitration or before the arbitration. Now, maybe I have opportunity to explain more in detail, during the discussion. Thank you very much.
Thanks. I certainly, Kevin, I certainly want to unpick your experience when we are talking about hybrid mediation. Now, Tezuka-san, maybe you can tell me whether the Japanese, like the Korean scene, would they also be interested in what is trendy, or or you may want to just tell me what is popular, whether mediation is popular in Japan.
Thank you. Let me focus on the mediation on commercial disputes between corporations rather than domestic small mediation, which may be taken by our court in many cases. And because of the notion of increased costs and time associated with international litigation and arbitration, Japanese corporations are more interested in settling the disputes through mediation in an international context. And under the COVID-19 pandemic, we've observed some stack in the court scheduling, and in particular, because of some logical challenge on the so-called exercise of sovereign power in relation to the examination of witnesses located outside of the jurisdiction of the courts. It is impermissible for the Japanese courts to take evidence from the witnesses residing outside of Japan through video conferencing and vice versa. So Japanese corporations are more and more interested in international mediation, and actually the government supports the promotion of international mediation by assisting the opening of the Kyoto Mediation Center, which is a Japan International Mediation Center in Kyoto. And also we have already enacted the amendment to the mediation-related law, that is the Foreign Lawyers Act, in which the scope of the permissible party representation by foreign qualified lawyers in international arbitration as well as international commercial mediation has been expanded and or clarified. And one popular question I've often received from the overseas colleagues is why Japan has not yet acceded to or joined the Singapore Convention. And my answer is that we are making preparations, such as foreign attorneys law and the Kyoto Mediation Center, etc. And we are actually deliberating on the amendments to the Japanese mediation regime to introduce the enforceability of a mediated settlement. But one big challenge is the argument that it would not be appropriate to make the settlement in international mediation only enforceable, but leaving the domestic mediation settlement untouched. So there are lots of arguments as to what extent a domestic mediation settlement agreement should be enforceable. That takes much time. But many of the international arbitration community people say that, okay, if you take so much time in reaching to the consensus to the domestic mediation regime, then just leave it, and we should proceed on the international mediation settlement enforceability only. That is the status. Thank you.
Thanks, Tezuka-san. It's so interesting. My own belief is sometimes it's better to chew smaller parts than try and solve the whole entire world problems at one go. I hope if that approach is adopted, Japan signs up to the convention, and Meng will be very happy, and we all will be very happy. And Pak Fahmi, to you now. Maybe you can tell us what's taking place in Indonesia and how much take-up is there on mediation.
Thank you, Bazul. In Indonesia, the mediation gained popularity in terms of the use of the term mediation in some legislation like intellectual property, construction, financial dispute, consumer dispute, land dispute, and recently the most heated issue is restorative justice. But on the ground level, despite of the high settlement rate, mediation, like in our previous institution, amounted to 70.6% settlement rate, in PMN, 83% for out of court, and the small recent PMN survey, 88.6%. But in general, the use is still quite low. The most used here is as a court-ordered mediation, which is because compulsory to almost all civil cases. Good news is Indonesia, during this pandemic situation, they have enacted e-court and e-mediation. Some my friend lawyers advise that they postpone the court and the mediation due to COVID. So still unsettled actually. From what interesting from our recent small survey in PMN, there are some findings why the popularity is still quite low on the ground level. Most of the respondents said that the respondent do not understand the function and role of mediation. Some parties reveal that they were put off by the uncertainty regarding what the result of mediation. And when the mediation is attached to court, then they perceive that the process is convoluted and takes a long time. So it's all the result. We understand that lack of understanding of mediation still prevail in many instances, in many what so-called mediation. Some of them still cannot differentiate between negotiation and mediation. Sometimes I still have been questioned as what's the difference between mediation and arbitration. But maybe it's not many occurrences, but still there are questions about that. And in addition to that, some of the findings say that advocates do not popularize the choice with their clients, and they tend to prefer to litigation. Parties doubt if the agreement reached in mediation will be implemented because they assume that litigation is more enforceable and permanent. This is again we got the insight from lack of understanding of the consent judgment. Since 2003, if we have mediated settlement and converted to consent judgment, it will be final and binding. That's on the court system. And lastly, about the finding of the survey, respondents claim that the mediators do not spend enough time exploring each party's interest, and instead they try to match both parties' demand. I think it's similar to what you have previously mentioned, Bazul, that this happening actually more related to court annex mediation, which we see here, almost 98% the mediators are judges. Back to you, Bazul.
Thanks, Pak Fahmi. Pak Fahmi, looks like, given that I am an ambassador appointed by SIMC to Indonesia, I have my hands full, and I certainly will need your help in order to persuade the users. I believe that those are misconceptions. We need to do what we can to disabuse those misconceptions so that the advocates and the users will embrace mediation. Let's pick on the misconceptions a bit more later. Now, Raj, can you tell me something about mediation in India?
Sure, I think mediation in India is at a cusp of growing multifold. You have already seen the numbers which Meng has shown on the SIMC data. The numbers in India on mediations are growing exponentially. India is adapting to mediation much faster than probably many of the Asian countries right now. India is also taking very positive steps in mediation. India has been signatory to the Singapore Convention. India is also working towards ratifying the Singapore Convention. India is also working towards bringing up a domestic mediation law, and there is a very active group and a committee which has been formed to come up with a mediation act for India. Apart from that, Niti Aayog, which is one of the government bodies, is also actively promoting ADR and ODR as ways to resolve disputes. So there is a great push through the government to see that if many of these commercial disputes can be resolved through mediation. There's also great requirement for a solution through mediation in India, is because courts are really overburdened with work. They're really stretched with number of matters that are there. In the recent times, because of COVID, and because of which the courts have had limited functioning, matters have taken longer to get hearings. During this time, we've seen the growth of mediation multifold. We've seen a lot of parties choosing to attempt to go to mediation and resolve their matters there rather than actually litigating. They don't want to spend a lot of money at this stage. They find mediation as a cheaper alternative to a litigation, which will involve huge costs and much faster resolution compared to a litigation. Again, when parties enter into a settlement agreement consensually, they are far more likely to accept it and honor them. And therefore, the parties looking to go into mediation and resolving the matters through mediation is much, much higher. And surely, but slowly, a lot of commercial matters we are seeing are moving towards getting resolved through mediation, which was traditionally not the case. Traditionally, we saw a lot of family disputes, a lot of smaller disputes, partnership disputes getting resolved through mediation. But of late, we are seeing a big commercial disputes getting resolved through mediation. And I think that's a very, very positive step where India is moving towards. I think with bringing up of new legislation in mediation in India, that will also be a great boost for mediation in India. And SIMC and others are really making all efforts to promote mediation in India. They're conducting courses for mediators, and that helps because you need trained mediators. And unless you have trained mediators, they will not be in a position to give you an effective resolution of matters. So that's a very, very important step that's required, and which the institutes like SIMC are doing it in a big way.
Thanks, Raj. No, I mean, I would have thought that mediation would be really helpful in order to ease the heavy burdens the Indian judiciary has. You know, I can tell you from experience, I did a conference with a judge. I suspect he was from Chennai, I think, if I'm not mistaken. It's been some time. And the judge asked me, how many cases does a Singapore judge has on a given day? So I said to him, one. And that stretches for, if it's a trial, it stretches for a week or two, depending on how long the trial is. If it's a summons, maybe a few. But if it's a involved summons, it's just one. So he said to me, take a guess, how many cases I have. So I said, Judge, maybe what, 30, 20? He said, try 200. I was shocked. But I can understand from a population base of 1.3 billion. And that seems, at least at that point of time, to be the only mechanism to resolve disputes, as opposed to trying to, otherwise anarchy will prevail. If you don't have a proper forum for parties to resolve dispute, the country cannot function. So I would have thought that mediation is extremely useful in the context of the trying to ease off, as I said, the heavy burden of the judiciary in India.
You're absolutely right, Bazul. We are seeing judges on a daily basis having rosters of 100, 150 matters in India, and each judge. So there is huge backlog of matters. But one thing to the credit of the government and also what they've done is that they have brought in mediation as a precursor to litigation in the Commercial Courts Act. They have also brought in mediation before in the Consumer Courts Act. They have brought in mediation as a precursor in a RERA Act. So these are specialized acts and commercial acts where the government has said that you first try out mediation before going to court. So this is a very, very positive steps that are being taken to promote mediation as an alternate ways to resolve dispute and to see if parties can actually resolve it before actually litigating.
Thanks, Raj. Now, Dato, I want to hear from you, from Malaysia, the perspectives of mediation in Malaysia, and in particular, given that we have a pandemic around us, what legislation the Malaysia has introduced in order to facilitate settlement mediations?
Thank you, Bazul. The Parliament last year passed the temporary measures for reducing the impact of coronavirus disease 2019. The Act was passed in 2020, and after this, I refer that as the COVID Act. What the Act has done is that the Act changes some of the existing laws, and if there's a conflict between the existing laws and the COVID Act, then the provisions of the COVID Act prevail. There's a special part of the Act, part 2 of the Act, which deals with inability to perform contractual obligations. So what this part of the Act provides is that from 18th of March 2020, until now it's 30th of June 2021, but based on the recent lockdown, it'll be extended maybe until the end of 2021. What it does is that all matters where a particular party is unable to perform his part of the obligation, then what can that party do? Section 7 says the defaulting party, you cannot take any action against the defaulting party. That means that if there's a default on one side, purely because of the measures taken by the government to prevent the spreading of the COVID-19, your only recourse is to go by way of mediation, and you cannot file any action in court. So the Section 9 of the Act provides for the government setting up a mediation center. And basically, not only setting up the center, the section also allows the minister to determine the mediation process. And this includes the appointment of a mediator, the role of the mediator, conduct of the mediation, and conclusion of the mediation. Now, upon conclusion of the mediation, the parties shall enter into a settlement agreement, and this agreement shall be binding on the parties. So if a party has defaulted in the contractual obligations, they go before a mediator and enter into settlement agreement, then your right for recourse is only for the non-compliance of the settlement agreement, but not the breach and so on. So the Act protects one of the party who is unable to perform because of the measures taken by the government in respect of COVID-19. But this is not in respect of all contracts, because there's a schedule in Part 2 which says it's only related, it's only if it's related to 9 categories of contract. The first one is construction contracts, and this will include consultancy, supply of materials, supply of labor, supply of equipment, and so on. The next one is on performance bond. The third one is professional services contract, contract involving lawyers, services, architect services, and engineer services, and so on. The next category is for lease of tenancy of non-residential immovable property. If residential property, then it doesn't come under this, but commercial properties, yes. The next set of contracts allowed events-related contract like catering, wedding, conference, exhibition, sports, etc. The next level, the next type of contract is contract which are tourism-related under the Tourism Act. The next type is religious pilgrimage related contract like Hajj, Umrah, and so on. Hire purchase agreement or leasing contract entered into by micro enterprises, in particular B40 and M40 class of persons. And lastly, the credit sales contract under the Consumer Protection Act. So with the passing of the Act, the government then set up the COVID-19 Mediation Centre. And this center is run by the government, but because the government do not have mediators who are accredited to the center, therefore the government then worked closely with the Malaysian Mediation Centre, and the Malaysian Mediation Centre then provides them with a mediator to resolve those disputes. So currently we are doing a lot of mediation work under this provision, and to a certain extent it's working well in thriving in getting parties to resolve their disputes in relation to matters which they're not able to perform due to the measures taken by the government under the present provision of the law. Thank you, Bazul.
Thanks, Dato'. Hopefully there would be a positive experience coming from this forced mediation as the only route to resolve dispute during this pandemic, such that once the restrictions are lifted from initiating proceedings, parties would be used to the idea of mediation and adopt mediation as a first approach to resolving dispute as opposed to last approach. Let's see how things turn out. Now, since we are on the question of pandemic, one of the things when the pandemic first hit us, I was extremely reluctant on doing mediation by virtual mediation. I can tell you that. I mean, I spoke to Meng about this. I expressed my reluctance because I was thinking, hang on, how do you bring forward a settlement if you don't have that physical contact with the decision makers? If you can't sit with them, can't talk to them in the same room. But having conducted hybrid mediation, and here I need to clarify, what I meant when I said hybrid, it's very different from when I used the word hybrid earlier. There, the word hybrid meant where there's a clause which provides for arbitration, break the arbitration, go for mediation, and if there's a settlement, good. If there's no settlement, continue with the arbitration. So that's when I use the word hybrid, that's what, and Meng used that as well, that's what we meant. Now, when we speak about hybrid in the context of holding a mediation during pandemic where parties cannot travel, what we mean is having a physical mediation as well as a virtual mediation. And Meng, I want to ask you this question. I'm sure the others would want to know as well. Is mediation still effective if it is done through the virtual mechanism?
Thanks, Bazul. And I'm sure many of the esteemed panel who are our specialist mediators, our ambassadors, our international mediators will be able to attest to it as well. In fact, the hybrid method of mediation where you have some of the lawyers or the parties are available being physically in the room itself together with the mediators, and the other parties who are overseas who obviously cannot travel this time because of COVID, join online. That has been very successful. Just this week alone, this week we happen to have 6 mediations that's happening over the 5 days. And out of the 6 mediations, 4 of them are hybrid in nature. One is completely online, one is completely in person. So the majority of the cases that we see now are hybrid because most of our parties are overseas, and our experience has been one where not only is hybrid bringing the parties closer together, but there are actually certain advantages. I agree with you. For mediation, one would think that being physically in a room, looking at the other person in the eye, getting that energy in the room, that spirit of collaboration is all very important. But there are certain advantages to technology and to hybrid that has worked very well for us. I'll give you some example. One is access to the CEO and CFO. We had a mediation in Seoul, in fact, Kevin might recall, we had a mediation in Seoul where when it came to the settlement itself, the parties then contacted the CEO of the US party to ensure that he's aware of what's happening. And of course, as the CEO, he can't possibly be flying to Seoul for 3 days, 4 days for the mediation, but he's available for 2 hours to get a sense of where we are and have the mediator talk to him, etc. So the access to the top level of management, whether they are the CEO, CFO, and now of course with pandemic, we can't travel, but I think in future, when we can travel, you can catch them whether they are in a ballroom or holidaying in Bahamas, for example. You can still catch them for the 1 hour to make a decision. That's invaluable, right? So access to senior management. You mentioned that you had a mediation organized within 2 weeks. If you have everyone physically in Singapore flying in, that's always a challenge. But now with online, you can do that very quickly. You can set up a mediation within a week or so, and have parties call in, and you can structure your mediation with pockets of time. I mentioned that mediation that we had for AnJie over 5 days. That was how we organized it. It wouldn't have been possible to do that if it's pure in person. And the last thing that I would just want to refer, also in reference to that AnJie case, is the ability to refer to documents is really spot on. You think about an in-person meeting, right? You want to refer to a document, you have to make copies beforehand, you got to hand it out, and then you got to ask the person on page whatever, you highlight that portion, and you don't know whether the person is reading it because they are more interested in the context, and so they are reading the paragraphs before that. Whereas in an online mediation where it's hybrid, as SIMC, we have all the documents being carefully tabulated, and we are talking about a massive amount of documents. Within the split second that the mediator say, oh, what about document number 23? This particular email sent by so-and-so, we're able to draw it out immediately, flash it online so that everyone can see it there and there. So that reference to document really is seamless, and it helps to create a momentum for the discussion, because a lot of this discussion is slowed down by whatever logistics they are, but because we're able to do this seamlessly, it is so much more effective, and the parties are able to talk about it without having to wait, etc. So the train of thought of the mediator, of the parties, is not lost as a result of any delay in referring to documents. So just some examples that I could give as the ability to incorporate others, the ability to reference documents, etc. So it's been a very, very positive experience. Having said that, when we can go back to in-person, that's my preference, but we're really making the most of it. I think going forward, it will always be a combination of in-person, hybrid, online.
That's so interesting, especially the last comment. It seems to me from what you have said that it does make sense for the hybrid to continue even after the pandemic. Think about it from the perspective of giving the blessing. So when in a large company, it's the board which makes, and you can't bring the board into the mediation room, but you can have the members stand by and participate and get the consensus fairly quickly in order to reach a settlement. My experience when dealing with a large institution in the past is after an in-principle settlement is reached, we still need to have the board sign off much later, or the key decision maker to give his blessing much later. With the hybrid, now it's possible. So that's truly interesting.
Bazul, can I add just one point about hybrid and the danger of having one in a room? What we have found that when we have a physical mediation, you're limited by space. So you might have 15, 20 people physically there. When it comes to a hybrid mediation, we've found that sometimes the parties request for 20 people to be on, 30 people to be on. So imagine an online where you have basically 50 people online. For the mediator, it's very difficult. So for all our mediators, we would advise them to be very judicious about who should be attending a mediation, even if it is hybrid, even if it's easily accessible online, because you need to be addressing the concerns of each one of them, and you don't want a decision to be delayed or scoffed at by some members. So it's important to have the right people, just the right size, even for a hybrid mediation, and not be allowed to have a mediation of cast of thousands, right?
Yes, very valid point. In fact, interesting. I did a mediation recently with George. We all know George. He was at the picture, that interesting picture. Now, many pictures, in fact. Now, one of the things which George said in that mediation is, hey, your chaps, so many of them are attending. Can we restrict the numbers? So I said to George, I don't think that is it's sensible, because to say to someone, don't attend, leads to questions. Some of them may well be pure audiences. I can understand that. but some of them may be slighted by the suggestion you don't attend. So maybe the other approach I said is to identify who are the key decision makers. So when you are focusing on them, as opposed to not knowing who to put your focus on just because there are 50 of them turning up in Zoom. So maybe that's something which I thought I'll raise. Now, I want to touch on enforceability, and because it's a very big worry. Still, the convention has not been ratified by many countries. So it's a valid point for users to say, hang on, arbitration is an award. With the New York Convention, I can enforce it with 100 over countries. With court order, again, it's an order. I would be able to enforce it if there's a bilateral treaty, if it's a multilateral treaty, and if there are assets in that particular jurisdiction, I will go in and enforce the court order. What about a mediation? What's the point? I mean, is it worth more than the paper which is printed on? So that's a real concern. Maybe this is to Lionel. Lionel, can you tell us how mediation or mediated settlement can it be enforced, or is the concern that it's not worth the paper printed on real?
Yeah, I think it's a very important question for businessmen, this enforceability. And I think I would tackle it in three ways. I think firstly, if the mediation process is something that the participants they feel engaged in, I think they are far less likely to then breach the agreement. That's one. But obviously, it needs to have teeth, right? So the next is, can this mediated settlement be somehow enforced through maybe, I think as what Meng said, through the processes like up, met up, or met up. So in up, met up, you have a situation whereby you start an arbitration, then you interpose with a mediation, and then you convert it into a arbitral award, which can then be enforced in this over 160 countries via the New York Convention. And then I think, as Meng said, there's also the met up regime where we have a mediated settlement. You can have it registered as a consent award in China, as I understand, and then that can then be enforced as well under the New York Convention. So other than this ways, by sort of converting the mediated settlement into an arbitral award, what we have in Singapore is that obviously if there are legal proceedings between the two disputing parties, then when they have a mediated settlement, they can then go back to the Singapore courts and record this mediated settlement as a Singapore judgment. That is one way. The second way is basically through the Singapore Mediation Act. And there's a section 12 in the Mediation Act, which basically allows parties to, even without any legal proceedings being commenced between parties, provided that certain criteria have been fulfilled, you can actually take a mediated settlement. I mean, there are some certain conditions, like it has to be administered by a recognized mediation service provider, and thankfully the SIMC is one of them. Then you can then have this mediated settlement then registered as a Singapore, or converted into a Singapore judgment. And that is where you benefit or leverage the fact that Singapore has these bilateral and multilateral treaties with other countries. So let me start with the bilateral treaties. I think we have those with a number of the Commonwealth countries. I think the important ones you have are the bigger ones. I think UK, Australia, New Zealand, Sri Lanka, Malaysia, Pakistan, Brunei, Darussalam, and I think there are also in India, yeah, how can I forget India, and also PNG. So I think it's in Singapore, we call this the Reciprocal Enforcement of Commonwealth Judgments Act, or RECJA as we commonly know this. So through this mechanism, you can actually have, obviously, the judgments of these countries recognized and enforced in Singapore, and vice versa, these judgments of Singapore can then be enforced in these Commonwealth countries. Now, in addition to this RECJA, there is this other act called the Reciprocal Enforcement of Foreign Judgments Act, and that is basically a regime whereby if there's a reciprocal agreement between another country that can be also enforced. I think currently we only have Hong Kong SAR, so that's another way you can actually take a Singapore judgment and have that registered in Hong Kong. Other than these sort of bilateral treaties, there's also obviously the Hague Convention, the choice of court, the big jurisdictions that have signed and ratified these are the EU, UK, you have also then Denmark, Mexico, and Montenegro. And we have at least two big jurisdictions who have signed but have not ratified it. So we hope they ratify soon. So these are China and the US, two of the biggest economies in the world. So basically through these multilateral and bilateral treaties, Singapore a court judgment that was previously a mediated settlement can then be enforced in these countries. And I think in addition to these bilateral and multilateral treaties, we also have this protocol of a memorandum of guidance and understanding that we have, or our Chief Justice have signed with certain jurisdictions. So for instance, I think there is a MOU or MOG together with China. There's one with the DIFC. And I think there are a couple as well. Let me just have a look. Yeah, you have one with Bermuda, Qatar, and also with the Abu Dhabi Global Market Courts. So these are enforcement of money judgments. And basically it sets a clear guideline as to how money judgments in Singapore can then be enforced in these jurisdictions. So if you have a mediated settlement that is converted to a Singapore judgment, and it's a money judgment basically, you can then take the MOU and MOGs as sort of your roadmap to have them enforced in these jurisdictions, and basically not just have a piece of paper, but something that can be converted to monies and money in your pocket. That's very important for the business people. That's all, Bazul.
Thanks, Lionel. Very helpful, very comprehensive, very helpful. Kevin, early on, you wanted to talk about hybrid in the sense of met up, met, your experiences. Could you maybe now touch on that?
Hey, thank you, Bazul. Maybe I can explain just the 4 stories, successful stories for Korean parties. The first one is directly related to SIMC. SIMC had a mediation in Seoul. At that time, it's the in-person mediation. That 2 parties attended the mediation, and mediation extended longer than expected. And that was finally settled in the midnight. That's quite fascinating story. And both parties quite happy. That happens understand that is in the middle of arbitration. That case, I'm not personally involved. I heard that story from SIMC, and I was recommended as a co-mediator, but one party objected, so I could not attend. But the other 3, my personal experience, the other one is also in Singapore by Singaporean mediator. We had the arbitration in Australia. The parties are very serious. They have in Australia, as you know, there is some adjudication process before arbitration. So the parties actually, they adjudicate, they failed. And then just before the arbitration, actually we already filed arbitration when the both parties make a submission. And before we be serious into the arbitration process, we proposed that maybe can mediate just one day in Singapore. And the other side accepted, so we agreed to meet in Singapore. Our client say, actually, we have, maybe it's difficult to settle, so they have no expectation to settle. But CEO himself went to Singapore, and we have a wonderful mediator. I don't want to name the person, but he's a really wonderful mediator. And then the case settled. That case settled within a day. So that, and both parties quite happy with the result. The other example is that we have mediation in London. This is very huge company, a very reputable company. Both companies have a huge dispute. The arbitration in Hong Kong. We actually did the first phase of arbitration. The case was bifurcated, and we decided on the liability issue on one point, one issue, very, very serious decision. And then we're expecting to have second phase, that is also liability and quantum. And both parties agreed to mediate in London. And we agreed London mediator. And this time, actually, the huge group, a lot of lawyers, together with the executives of both companies. And we have wonderful mediator in the case, and he's very skillful in a lot of preparation. And it was about 2 days, and parties settled. It's a huge dispute, and that both parties actually very respectable companies. They didn't want to lose their face in a serious dispute. That actually good contrast with our previous experience, another mediation in London. In that is case in Canada, we agreed to have a mediation in London, a different mediator. Actually, we really wanted to settle the case. Both parties, that is perfect case for settlement. Actually, that's kind of construction energy type of dispute. But mediator was not that skillful. And then we spent 3 days, a lot of effort. It failed to settle. So I was quite disappointed. The case is still going on. And the other successful story is the mediation in LA. That is also mediation, just a very early stage of arbitration. And we had good mediator, and the parties have good discussion, but failed to agree. So actually, we are quite disappointed because we have good progress, so we couldn't settle. And then I heard about 3 months later, the parties continue to discuss without us and settle the case. So, but it's based upon the discussion, the quite frank discussion we conducted in LA, really helped the parties settle the case. So that is the very happy experience I have. I have another experience actually that had in other cities, which we failed to agree, and the arbitration still continue. But that is actually because mediation just takes just 1 day or 2 days. Nowadays we are doing just virtual meeting. I found this quite effective. I normally recommend the client that they seriously consider the possibility to set aside just 1 day or 2 days to mediate. And because my experience, the result is very positive. So that's I want to share with my experience with the Korean parties involving the mediation.
Thanks, Kevin. Now, I will be remiss if I don't ask Tezuka-san. about his experience in mediating in Hawaii. And also his inputs on MedUp, if he has any. Tazuka-san.
Yeah, actually, what I had was a very famous California-based mediator, Tony Piazza, and who regularly recommends to have a mediation session in the island of Maui, where he has a house there. But unfortunately, for my first case with him, because of the scheduling issue, the parties agreed to have mediation session, not on the island of Maui, but in San Francisco, where he has his office. But still, it's a nice place to mediate. And actually, his idea of using island of Maui as a mediation venue inspired us to decide to set up the Japan International Mediation Centre in Kyoto, because it has the same quiet and calm atmosphere, and there is a good incentive to settle on day one rather than continuing on day two, so that you can enjoy yourself on the day two. And talking about the hybrid style of mediation, I would like to say, point out first that there are lots of bar associations, mediation centers, and they call that center as an arbitration center. But in fact, many of the cases start as a mediation. And during the course of the mediation, it may turn into, transform into arbitration. So this is a typical med-art. And typically there are two situations that supports such transformation. One is that the parties have agreed to many of the disputed issues, but there remain some issues on which the parties cannot agree. And then the mediator may turn into an arbitrator to decide on such selected few items as arbitrator. And the parties will know the scope of the possible consequences. It's not a 0 versus 100, but because the issues, disputed issues, are somehow narrowed down, they will know that the possible outcome will be in the range of 40 to 60 or something. So that is one possible example of made up in the Japanese Bar Association Arbitration Center. Another one is to make the settlement enforceable, even with the Singapore Mediation Convention type of legal regime. And many of the mediated settlements includes certain provisions to make it certain that the payment is made, such that unless the payment is made by certain dates, the underlying case will continue rather than terminate. But there can be situations where the parties' mediated settlement agreement include certain installment payments or some continuous obligations to be performed. So then there is a good incentive for the parties to make the settlement agreement in the form of a kind of consent award. so that the installment payment obligations or continuing obligations included in the mediation settlement becomes enforceable instrument. And one other thing I wanted to mention is that the parties really wants to avoid the simple waste of time and money by using the a simple mediation rather than a hybrid type of scheme. So they fear that if they only agree to mediation, then it may or may not be successful. And if it is not successful, as illustrated by Kevin, it is so disappointing. Maybe the the parties would feel that the mediation efforts are simply waste of time and money. But depending upon how the mediation is conducted, it may come up with certain feedback to the decision maker. And when JCAA amended its arbitration rules around 2013 or 14 to introduce an explicit provision for med-arb, I was a member of the Rules Revision Committee, and they introduced some med-arb provisions. And I proposed that they include certain mechanisms to encourage the parties to be more serious in getting to the settlement in the course of the mediation by introducing something like a sealed offer or UK litigation Part 36 offer. That is the mediator makes a proposal and the parties will have some response, right? And if they cannot agree, then such kind of a communication is confidential to the arbitrator. But at the end of the arbitration proceedings, and when the arbitrator finalizes the substance of the award, except for the cost allocation, he or she is allowed to open the sealed envelope and see what was the parties' behavior during the course of the mediation and in light of the mediator's proposal. So the arbitrator may have some discretion to allocate the cost in the favor of the more serious party or more good faith party. But at that point, unfortunately, that kind of proposal was not accepted by the other members of the Rules Revision Committee. But I wanted to point out that ICC now explicitly refers to the sealed offer so that they can assist the parties to use such kind of mechanism to encourage settlement. Thank you.
Thank you very much, Tezuka-san. Interesting ways, creative ways to make sure that it's successful. Now, on a lighter note, maybe we should have something like that in Singapore or in Sentosa. I mean, that's the closest we have to an island. And if not, I mean, maybe we can lean on our Indonesian friends, Bali. That's not a bad idea, to have a mediation in Bali, assuming after the pandemic is over.
Yeah, yeah, for sure. I'll be the first to go.
Yeah. What I want to do now is take a few minutes, each panelist. I will go through each panelist. Take a few minutes. Tell me from your perspective, what you think, from where you are coming from, knowing your own users in your jurisdiction, what would you recommend as best practices to in a mediation to reach a settlement? Take 1 or 2 minutes because we are coming to an end. We want to take on some questions as well, if that is possible. So can we start with Meng?
So the question is, what are 1 or 2 practical tips in order to ensure settlement, right?
That's correct.
I think based on my experience, the preparation of the mediator is absolutely critical. A mediation, whether it succeeds or not, almost is determined even before the mediation starts almost, because if the mediator does the preparation and they work with us to talk to the parties beforehand, I think that's very important. I know some mediators are not comfortable with doing some pre-mediation discussion because they are concerned that they'll be considered as being biased, etc. But my own experience has been that if you do that adequately and really explore that, that will really improve the chances of settlement. The other thing that I would raise would be cultural sensitivity. I cannot put enough emphasis on that. I think Bazul, you spoke about it. Several of our panelists also spoke about that, because we come from such diverse background and cultures and nationalities, and we are talking about cross-border disputes. It is very easy to make certain assumptions. The one that Kevin talked about, the case that was in Korea that actually was settled in Korea at midnight. I'll just give one very simple example. It was a US party and a Korean party. And the Korean party felt that the US party wasn't giving enough respect to the Korean party. The US party felt that, oh, it's just business. So the mediator actually started that mediation, not with a usual introduction, but with serving tea. Korean tea to both sides. He actually physically served both sides. And that broke the ice for the mediation. The Korean party felt that it was a matriarch, so she felt that she was being respected. And the US party felt that, hey, this is very unusual. And they were able to dig much deeper into the interests of both sides and start speaking on the same wavelength. So understanding the culture, preparation will be the 2 things I will highlight.
Thanks, Meng. I mean, I feel I'm very lucky to be in Singapore because, in the course of a day, I pick up the phone, I speak to my American client. After that, engaging an Indonesian solicitor, Indian client, Chinese solicitor, on occasions, Germans, Turkish. One of the things which jump out, and of course, Japanese, one of the things which jump out is the cultural differences. How yes is not necessarily a yes, a no doesn't necessarily mean a no. How some would want to, talk about the family before they get into the real issue. Some would take that as an offense. Time is precious. Go straight to the heart of the matter and get it resolved. So understanding culture is so important to our business resolving dispute. You're spot on. Now, can I turn to Raj? Raj, can you give me some best practices you think would be useful?
So I would quite agree with what Meng said. Preparation as a mediator is extremely, extremely important. You should, when you are meeting the parties, they should feel and be comfortable that you know what we are meeting for. You understood their issues. If you've done a pre-mediation meetings, otherwise from the papers that they've been filed before you, that you've gone through it properly, you've read it thoroughly. In countries like India, where there are so many different cultures within India, right? Like we have so many different states. Each state has its own culture. it's also important to understand the cultural requirement of each community within a country. It's very, very important to understand what they are, where they're coming from, what they want, how do they consider a few things being said are. So it's important to understand that. Be very transparent as far as possible. Don't have side meetings without the information or without communicating with the other parties. Don't give any sorts of doubt in the mind of other party that there is something that's being done without being told to them or being communicated to them. That will definitely be a disaster for the mediation. So anything that you do should be completely transparent, well read, give enough opportunities, have your caucuses. Don't not have the caucuses for sure. You have them. That sometimes really helps in breaking the ice, because that helps sometimes party to call you and tell you that what are the issues that they are seeing and facing, which may help you when you are having a joint session again to resolve them and to bring parties closer. So I think some of these things are very, very important. I think to my mind, mediation is just the smartest way to resolve disputes, smartest way to resolve all your commercial disputes rather than litigating. Parties are there, as commercial parties are there to do business, not to litigate. The business is to carry on with the work and not litigate.
Thanks.
So to my mind, that's the smartest way to resolve matters.
Thanks, Raj. Very helpful. Dato, do you want to weigh in?
Yes, yes, Bazul. Actually, I agree with both the earlier speakers. One of a better method of getting a positive result in mediation is also, to a certain extent, get the parties themselves be prepared for the mediation. What I mean here is, maybe during the pre-mediation conference, the mediator can get each party to think out of the box. As we know, mediation allows parties to look beyond the litigation-based positions. Get the parties to list their options based on their needs. Get the parties to put themselves in the shoes of the opposite party and see whether the options which they are proposing is acceptable or not. This is to ensure options are made realistic. And from my experience, after preparing them, we are able to resolve most of the disputes at a faster pace. In fact, at a very early stage of the proceedings, we get parties to agree and record settlement agreement. So from my experience, I think getting them to do this helps a lot in resolving the dispute very much early in the day of the mediation proceedings. That's all, Bazul.
Thanks, Dato. Thanks. Pak Fahmi, your turn.
Thank you, Bazul. I think I have the same experience with other distinguished panelists. In my experience, parties need to show that the plan or proposed mediation plan is based on good faith. It will be a collaborative problem solving. It will be a safe zone and not in adversarial mode, which is wise to consider that the approach to adverse party is coming from a mediation institution as the neutral body like PMN or SIMC. Secondly, I pose a question, is there any Asian approach to mediation? And this would relate to my observation, my experience. Try not to ruin the situation by giving wrong impression, like summation, blaming, reporting to authorities, sending personnel with less authority. And secondly, on the cultural aspect is appreciating the culture. Do not rush, especially here, I think. Do not rush. Try to make other parties feel respected, a perception of safe zone, assign negotiators with competent in collaborative negotiation as far as feasible to make the situation conducive for productive negotiation, at least not a hawkish one. At this point, I think we shall contemplate whether people are rational at these cultural issues. The last thing is preparation. Means parties should maximize the pre-mediation meetings, which is where we can learn the fit culture required or should be aware of by the mediators and by the other parties. Back to you, Bazul.
Thanks, Pa. Arthur, maybe you can let us know what your thoughts are from where you come from, tips to reach a settlement.
Yeah, thank you, Bazul. The question is, what's the best practice to promote mediation, to get mediation more popular, to my understanding? I would like to share my observation from another perspective, that what's the obstacles, what's the difficulties for party to use mediation. So I share just a piece of information from my personal experience. One point is that for many, or maybe most of the Chinese SOEs, the state-owned enterprise, it's hard for them to use mediation. The question or the problem is that nobody wants to make a decision on the final price of the mediation agreement. So it is hard for the SOE to accept or to use mediation as a dispute resolution mechanism. Second is experience of mine is that when the parties from different jurisdictions, they may have different understanding on the mediation conducted in another jurisdiction. An example is that when I was a presiding arbitrator in CTEC, a company from Singapore, and as a claimant, as a Chinese company as the respondent. So it's very normal in China that after the closing arguments, the tribunal will ask, do you guys want the tribunal to be the mediator for you? It was found very useful in the practice of China, but here, the parties from common law background says clearly no, we do not want the tribunal to be the mediator. They found it a surprise that the tribunal asked this question. So they never use the same person who is arbitrator to be the mediator for the same case. So what my comments is that, what's the best practice to promote mediation? Maybe we need to do more to educate the users, and be open and be flexible to find the benefits or advantages of mediation for their business. It's a long way to go. Thank you, Bazul. It's my personal comments.
Thanks, Arthur. Can I ask Tezuka-san to...
Oh, yes, thank you. I first want to share with you what I have heard from the famous mediator Tony Piazza when he made his kind of memorial speech for the opening of the Kyoto Mediation Center. And he said that what he tries to avoid is to have the parties behave in a reactive manner, which he considers to be counterproductive. So the term reactive is what he always have in mind to avoid in order to make the entire mediation process more productive. And that is his tips. And my own tips is that it is useful to try to be creative enough to think about some tailor-made procedure for mediation depending upon the case. And in my experience, the parties and mediators agreed to have a just one day deposition of a very limited number of witnesses on a particular engineering issues, so as to narrow down the issues at an earlier stage. And in another fully online virtual mediation, we decided to have the interactive so-called interview session of two experts jointly appointed by both parties. So in an arbitration, for example, if there are two experts, it is often the case that one each is appointed by each party, and they somehow behave like counsel to the appointing party. But I wanted to have the neutral experts and the two experts on the same issue. And rather than having the nasty cross-examination against those experts, the interactive interview session was based upon their draft interim reports, which is subject to the parties' comment, question, and clarification, including the questioning as between the two experts. So it was very productive and helpful for the parties to understand the difference of the basic approach and the differences in the fact assumptions, etc. And this is an example of how you can use some limited evidentiary proceeding even in the mediation. So you should not stick to the idea that mediation would not involve evidentiary activities. I think a limited and focused evidentiary exercise can help the parties to have the better understanding of the case. Thank you.
So in short, be creative.
Yes.
Kevin, your turn.
Okay, thank you. I would say two skills for the mediator is quite important. The first skill is like the creativity, the creativeness, as the Zika-san pointed out. Like two sides of creativeness required. The first thing is the solution. So what parties want in that dispute, and they have find some creative way to resolve the dispute. But it's also you need some creativity in finding justification for the settlement. So party is quite difficult to justify, and they why they should settle the case. The mediator should provide some good reason to settle, and to justify the situation that the party is encouraged to settle the case. Another skill is avoiding conflict. Particularly in the joint session, it's quite dangerous. I saw many occasions just greeting session, the first joint session, already parties fighting each other. So the experienced mediator have a skill to avoid conflict. Many ways, like treating the dancing, tea, or whatever you want. You just have some way to avoid conflict. So normally I propose we should not have joint session until we have good progress in the discussion. So that, because my experience, joint session normally end of story. First joint session is okay, second joint session fine, and it just ended. So the mediator should pay very serious attention to the joint session in order to avoid conflict. Thank you.
Thanks, Kevin. We have covered with panelists the panel discussion or the subject matter of the panel discussion. Now, I think we should go to the Q&A. Let's look at this. So I have got a series of questions from the participants. Now, maybe the first question may be to address to Meng. How many mediation cases were conducted under the auspices of SIMC in 2020 and in 2021? What are the projections going forward? Meng?
Yeah, happy to answer that. For 2020, we had 43 cases, which was still a substantial growth from 2019. For 2021, we are in May now, and we have already 36 cases. So we expect to be hitting something like 70, 80 cases or more. So it's an exponential growth of about twice the number of cases based on the previous experience. But what I wanted to also emphasize is not just about the number, but about the type of cases that we see. One I did not mention, which I should mention with Hiroki-san, is that we have this joint protocol with JIMC, where we had one co-mediator from Japan and one co-mediator who is international for a matter between India and Japan. And that matter was resolved. They set aside 3 sessions. They settled it in 2 sessions. That's how efficient they are. So wonderful experience with the co-mediation, understanding the culture. And we also have one just last week filed with us, which is really a fantastic case, an investor-state case. As you know how complex investor-state matters are. So this is our first investor-state matter that we will hear. So growth as well as complexity. Thank you.
Looks like the prospects are really good for SIMC. Now, another question which I would like to be answered is, do you have any tips on choosing a good mediator who can help achieve a settlement? This is interesting. From my perspective, a good mediator is someone who would be able to garner the respect of the parties who are proposing the mediation. So if it is a technical dispute, someone who has the technical expertise. If there are cultural issues involved, someone who will be able to sit through and understand culture. And maybe I would like to ask Pak Fahmi, what are your thoughts on this question? The mediator, choosing a mediator. What would you say?
In PMN, when we have a case, we will give a shortlist mediators to be chosen by the parties. And in general, of course, usually the mediator will be recommended by the previous parties or previous lawyers who are advising the client during the mediation. Lastly, we're still preparing for that, is preparing stars for the mediators. So we'll prepare the mediators in PMN to have stars by the users. So it will make easier for the parties to choose among the mediators listed at PMN.
Thanks, Pa. Now, with this is to Meng. Meng, how would you deal with a party who's been difficult and appears to be obstructive at a mediation?
I think that appears in every mediation. I think Kevin talked about it, right? Once you have the joint session, they are fighting. It's just very hard to control. I think what he said about pre-mediation, I think I mentioned that as well, is important. We do the pre-mediation. So as a mediator, you kind of assess during your pre-mediation who the difficult parties are, who the troublemakers are, whether they should be physically there or whether they should stay in a room and not come for the joint session. So you have to manage some of these expectations. But even during the day of the mediation, what I learned is that you don't always necessarily have to start with a joint session. You could start like for the first 10, 15 minutes or so, meet with the parties, make them feel comfortable, get assessment on the day itself, who is feeling angry or upset. And then you try to address that. So what we normally do is that we do tell party during the joint session, the first joint session when we eventually have it, is to express what they feel about it. So they are angry, they're upset, they have to get it out of the system. And that's important. You get it out of the system. But we always tell parties to keep it short, not for half an hour, keep it to 5 minutes, at most 10, as to say what you want to say. But then, very, very important, we advise them, this is the pre-mediation before the actual joint session, is always say something positive at the end of that. And that is something that I learned, right? So you can vent your upset, your anger, but at the end you will say something like, but I'm here today. I'm upset, I'm here today. I'm trying to see how we can settle it. I appreciate the efforts of so-and-so for the last 10 years. It has been good. I'm sorry that we are in this place now. So something positive at the end always helps the other party to hear it for themselves, that this party is genuine in wanting to settle it. So that's one of the things we do. Of course, private session and all of that is very critical. So I guess that's one tip that I'm happy to share, and I've seen it being used very effectively in the mediations here.
Thanks, Wee-Ming. Arthur, in your experience, can you tell us what is the biggest challenge you have faced in a mediation?
Yeah, so in my experience that how to establish the confidence of the parties to the mediator maybe is the most challenging point for a successful mediation. Usually the party, when they having dispute already, so maybe they do not have full confidence, or maybe very less confidence of getting it settled. So how could the mediator give both parties confidence that he has experience in this industry, he could evaluate the positions of both parties and to find a common interest eventually. So it's the most challenging point to the mediate and to the successful mediation eventually.
Thanks, Arthur.
Yeah.
Thanks, Arthur. Now, Fahmi, there's a question to you. In relation to your use of the word good faith of parties as one of the important factors for a successful mediation, you are asked to elaborate on what did you mean by good faith?
Yeah, actually, I'm still writing, but I think better to speak out verbally. In here in Indonesia, in my experience, as well as in court mediation process, good faith, they have a proxy, they have the way signals how the other party can see that this is good faith. Like parties prepare themselves before mediation. They have option to be brought on the table, sending appropriate delegates, following the agreed schedules, and can elaborate arguments or reasons or underlying interests to other parties. I think that's the signals that can be understood by other parties that the party is having a good faith.
Thanks, Pa. We have come to the end of the session. Timing is perfect. Now, maybe I'll say a few words to close and hand over to Grace. Firstly, thank all the panelists. It was an amazing session. I learned as much as I suppose the participants. I enjoyed myself thoroughly moderating this session with all of you. Thank you very much for coming on and agreeing to come on. Now, what I have taken back from this session is it is so important to prepare. Mediation is not you turn up within an hour of being briefed. So if there is a perception that mediation is very easy, and can be achieved without effort, you would now have heard enough to know that it's not. Both the lawyers as well as the mediator have to have a substantial amount of preparation. I think a pre-mediation discussion is critical. I understand Meng has mentioned it, that some mediators do not like the idea of pre-mediation session, which may give the impression that they are siding or talking to one more than the other. I think the institution should actually introduce a process. So that way, it is not the mediator who is suggesting the pre-mediation session. A transparent process for a pre-mediation session. And in fact, sell that to the users. So as an example, the institution may well say, 1 week before the actual mediation, all parties will turn up. In court, we call it JPTC, pre-trial conference before a judge, so that the hearing can be properly managed. So we can have a pre-trial conference with a mediator where parties put our heads together in order to see what are the pain points which needs to be crossed without breaching confidence, of course, and what creative ways which can be taken up. The mediator can put forward the suggestion to the parties because he has an advantage of a party or the lawyer knowing his clients well, saying to him, that is not going to work. Please don't even try that. Because if you try that, you are going to lose the trust and it will blow up at your face. So I think the institution should think about putting this as a process. And I think preparation is really key. A complex dispute requires effort to work through it through a mediation. And I think culturally, as well as humans, we are susceptible to reasonable propositions. We don't like the idea of going to court, litigating, when if the matter can be settled through a amicable process. So thank you very much. And thank you for participating and attending, the participants for attending. Grace, can I hand it over to you?
Thank you very much, Mr. Bazul and panelists, for all your enlightening viewpoints. And thank you everyone for being part of our webinar. It has been a real pleasure being with you today. Please follow us on LinkedIn and feel free to follow up with any questions. And for business inquiries, you can email Partner, General Manager and Head of Business Development at Un & Bazul, Mr. Abdul Malik. You can email him at abdul.malik@unbazul.com. So stay well, everyone, and keep in touch, and see you at our next webinar. Thank you.